All right, hello again. This is Ben Hitchcock Cross talking to you today. What the heck? J-E-L-L. All right, we are going to go back in time to April 17th of 1969, and we're going to talk about Dolores Yanta versus Montgomery Ward and Company. This is sort of the history of Wisconsin employment law. This case is important because it's post the Wisconsin Fair Employment Act here, and we're still going to talk about how you can be fired for no reason or any reason at all. Sometimes they say a good reason, a bad reason, or no reason at all. All right. So I'm going to just mostly be reading through this here. I think we can look at it. Hold on. All right. This is a sex discrimination case. The principal issues raised on appeal is whether the plaintiff respondent, Dolores Yanta, states a cause of action, and her complaint filed in a civil suit commenced September 8th of 1972, following her discharge on April 17th of 1969. So this is like the Jack Benny program is over for just about 4 years here. We're going way back here. After proceedings charging a violation of sections 113, 111.31, etc. of the stats were instituted by Dolores Yanta, the discharge was found by the Department of Industry, Labor, and Human Relations. That is definitely the precursor to the DWD/LIRC, Labor and Industrial Review Commission. Okay. The Department of Industry, Labor, and Human Relations to be an act of sex discrimination. The department awarded prospective relief only, ordering the defendant to reinstate the plaintiff and to cease and desist from further discrimination. Okay. So she won in 1972. So pretty much 3 years later, she wins. Hooray. She doesn't sound like she gets any attorney's fees or anything else, and the only thing she gets is the right to have her job back. And I mean, it's no joke. It's just important to keep that in mind. What a precarious position she's in at the beginning of this case. Decision here. And they're being ordered to cease and desist from further discrimination. Gosh, my guess is that most people at that stage wouldn't want their job back, but who knows? All right. In her civil action, and I'm not clear if that means a ERD thing or what, but what we now call an ERD, administrative case or what. In her civil action, Yanta seeks damage recoveries arising from the following injuries: allegedly proximately caused by discrimination, lost wages, emotional and mental anguish and personal humiliation, personal inconvenience, and legal fees, and harm to character and reputation. After the defendant demurred to the complaint on the grounds that the action was barred by the statute of limitations and the complaint failed to state a cause of action, the demur was overruled by the trial court. Montgomery Ward appeals. Okay, so this is just a straight up civil action in civil court, and she's asking for exactly what anybody today would be asking for. Let's see what the law gives it. All right. We hold that the complaint in part does state a cause of action which is not barred by the statute of limitations. We therefore affirm in part, reverse in part, and remand for further proceedings. The statutes prohibit employment discrimination, this is 1969, based on among other factors, sex. These statutes are administered by the Department of Industry, Labor, and Human Relations, and at the time, the discrimination against plaintiff, the department had statute authority to issue orders preventing future discrimination, but could not violate remedies in the past. Apparently that's been changed. In Murphy versus the Industrial Commission, this court held that while the department, then the Industrial Commission, could issue an order to hire, reinstate, or whatever is appropriate to eliminate the discrimination in the future, nevertheless, the department has no authority under the Wisconsin Fair Employment Practices either to act either during or after conciliation or after hearing to award back pay to parties discriminated against on account of their sex and the wages paid them. Okay. Now, back to the headline. Why are we talking about this? So, when people today settle or are pressured to settle for a ham sandwich, for example, they are maybe forgetting all of the struggles that happened in the past. And we need to understand that this complaint here, as much as part of the civil rights movement as anything else, and getting the enforcement, because this is how laws work, okay? You can go up and march in the streets and you can get a law changed, but it's absolutely going to be the fact that if that law, for example, hurts manufacturers' commerce, something like that, then it's going to be opposed in the courts in tooth and nail, and they're just going to simply try to not do it. So first of all, and then unless and until the government gets involved and makes them do it, they're not going to. And this is what we're trying to go through here, sort of the history of what that's about. But why are we doing this is to inform people on some of the struggles that have come before them, and also to, I think, to inform the Department of Workforce Development and their cohort of ALJs of just exactly what came before them, and that these rules didn't just happen for nothing. And as small and as seemingly as insignificant as they are, or at least as clearly they failed to make the victims whole, nevertheless, these are hard-fought remedies, and they are rights. And people should not be giving them, nor be pressured to give them up lightly. All right. A recent amendment effective June 15th, 1974, so it took 5 years at least, now permits the department to award back pay. Let's see if there's a footnote. Okay. But this change in the law occurred long after the discrimination against the plaintiff and the subsequent cease and discrimination order of the department. So to you, that's what I get for that. Plaintiff's present action for back pay and other damages is grounded in the theory that these statutes create a private civil cause of action to recover for past injuries arising out of employment. Oh, all right. Let's read the law here for 73. This is the amendment apparently that took place in 74. If after hearing the department finds that the respondent has engaged in discrimination, it shall make a written findings and order such action by the respondent as will effectuate the purpose of this subchapter with or without back pay. Back pay liability shall not accrue from the date more than 2 years prior to the filing of a complaint with the department. Oh my goodness. I don't think that's in there. Interim earnings or amounts earnable with reasonable diligence by the person discriminated against shall operate to reduce back pay otherwise allowable. That's mitigation. That's basically in there. Amounts received by the person discriminated against as unemployment shall not reduce back pay otherwise allowable. It shall be withheld from the person discriminated against and immediately paid to the Unemployment Reserve Fund, or in the case of welfare payment, to the welfare agency making such payment. Okay. That is fascinating. I'm going to pause here and see what it is today. All right, here we go. If after hearing the examiner finds that the respondent has engaged in discrimination, unfair honesty testing, or unfair genetic testing, the examiner shall make written findings and order such action the respondent as will effectuate the purpose of the subchapter with or without back pay. All right. No welfare. There's no 2-year limitation anymore. Reinstate compensation in lieu of reinstatement front pay may not be less than 500 times more than 1,000 times the hourly wage. I mean, 6 months isn't like shocking, but you know. Okay, It does say back pay liability may not accrue from a date more than 2 years prior to the filing of a complaint with the department. Interim earnings or amount earnings with subject to yada, 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 otherwise allowable. That's pretty similar. Okay. Thanks for going down that with me. All right, statutes. However, the plaintiff relies particularly on the following sections in arguing such a case of action is implied. Okay, so this kind of argument is this. It's not the cause of action is not necessarily in the statutes expressly. It's implied, which can happen, and sometimes for the need to do it, it's just that's a way bigger hurdle to get past. But it has happened. And really, again, to be clear, the ask is to say that basically Wisconsin Fair Employment Act to actually, it is implied in there because of all these statements that clearly state that you have the right to these remedies, that you should then have the ability to go in circuit court to file them. And I'm only making it sound, I don't think I'm even intentionally making it sound strange. I think it sounds strange because it's not been the law for 50 years. All right. Here is the reason, the lofty words of the statute. Declaration of policy, the practice of denying employment and other opportunities to and discriminated against properly qualified persons by reason of their age, race, creed, color, handicapped, sex, national origin, or ancestry is likely to foment domestic strife and unrest. And substantially, that means that there was a bunch of protests and we didn't like them. And substantially and adversely affect the general welfare of the state by depriving it of the fullest utilization of its capabilities for production. We didn't like it because people weren't working. So, in that context, we can see how it's very easy to see the DWD Equal Rights Division as merely an escape valve for sort of the pressures of discrimination, right? Because people are likely to, we're not doing it to solve the problem, by the way. We're doing it because for the general welfare of the state, because it's depriving us of the use of these workers here because they're getting pissed off, that we're going to create this DWD thing that's going to sort of make it so that these workers are not pissed off. And I think if you read it in that sense, it's very easy to see why the DWD does what it does. The denial of some employers, licensing agents, and labor unions of employment opportunities to such persons solely because of their age, race, creed, color, handicap, sex, national origin, or ancestry, and discrimination against them in employment tends to deprive them, the victims, of the earnings which are necessary to maintain a just and decent standard of living, thereby creating a grave injury to them, emphasis added. And you can see here that the place that they're adding this emphasis, this court is adding this emphasis, is on the deprivation of the earnings which necessary to maintain a just and decent standard of living, thereby creating a grave injury to them. And I 500% understand why that person would believe that they are able to sue based on that statement. Totally get that. Totally get why the courts would prevent them from doing that too. Okay. Wow. I do think that the Department of Workforce Development, even under Democrat Tony Evers, takes the first view, that is to say, being a safety valve for the fomentation of domestic strife and unrest, and depriving it of the fullest utilization and capacities for production. I think that is their number one concern, moreover than the harm. All right. It is believed by many students of the problem that protection by law of the rights of all people to obtain gainful employment and other privileges free from discrimination because of age, race, creed, etc. I'm just going to say etc., not to minimize them, would remove certain recognized sources of strife and unrest and encourage the full utilization of the productive resources of the state to benefit the state, the family, and all the people of the state. It's a little redundant, but okay. An interpretation and application of this subchapter and otherwise, it is declared to be the public policy of the state to encourage and foster the fullest extent practicable. This subchapter shall be liberally construed for the accomplishment of this purpose. And you can see again why this is pretty good support for there should be a civil remedy in circuit court. Now I understand what they're saying here. And this is, remember, in the federal scheme, there's this ERD, and then you go to court, real court, starting all over again. In the state system, there is the ERD, and then you go to circuit court for review of whatever the ERD was up to. Only after LERC makes whatever decision it may make whenever it decides to make it. Different. Definitely different. And I'd say the Wisconsin system is worse. No doubt about it. Okay. Now they keep going. I think this is great for us to all go through this, what the law is here, and because it's more or less the same. It is discrimination because of sex for an employer, labor organization, what it's an employer, or person to refuse. We would pretty much nix out person these days because it doesn't mean what that means, like the person who's employing somebody in this personal capacity, as opposed to like a larger employer. To employ, admit, or license, or to bar or to terminate from employment or licensing such individual, or to discriminate against such individuals in promotion, compensation, or in terms, conditions, or in privileges of employment or licensing. And remember, it was absolutely common for certain labor unions, to maintain that they were completely white. So that, the carpenters union may be completely white for that reason. It was also possible for licensing people, like to police enforcement boards and other things like that, were just straight up discriminating against people. So that's why those are in there. That's less common now, I think, because licensing agencies and labor organizations have less clout than they did before. Unlawful to discriminate. It's unlawful for any employer, etc., to discriminate against any employee or any applicant for licensing. Okay, I guess these are what she's pointing to again in the statute for the proposition that she, yikes. This is really, I guess, a good lesson for all of us. So let's be careful here. She was. I'll read it. To support her contentions, plaintiff relies on Article 1, Section 9 of the Wisconsin Constitution, providing that every person is entitled to a certain remedy for all injuries. And I want to say that is very tantalizing, and that is one of the most annotated articles of the Wisconsin Constitution that basically says that exactly what she can't do, exactly what this law does not do, precisely what she's trying to make it do, which, again, totally understand why she's trying to do it. Totally think that the rulings that say that you can't do that are wrong. But I also understand why judges are going to want to have as few remedies as possible, because it makes their life easier, among other things. Okay, and there's the decision from 1971, Murphy v. Miller Brewing Company, all right, a noted Milwaukee employer, now Miller Coors. This court held that authorizes private causes of action for sex discrimination. All right. Defendant, on the other hand, argues that Murphy never reached the question of whether private actions are maintainable. Defendant then relies on Ross v. Ebert, where this court held that the express statutory and administrative remedies for employment discriminations were exclusive, and that therefore no private cause of action could be maintained. The parties' opposing views concerning Murphy versus Miller Brewing must be resolved first. We would agree with the defendant that the court did not decide the question of the propriety of private employment discrimination actions. The plaintiff, in that case, pursued a civil action to recover back pay based on a legal sex-based salary differential. After this court in Murphy versus Industrial Commission held that the commission could not award back pay, the defendant Miller Brewing Company moved for summary judgment on the grounds that the circuit court had no subject matter jurisdiction and that the complainant failed to state a cause of action. Complaint state to fail a cause of action, meaning you couldn't get back pay or it wasn't illegal. Whatever they were accused of doing, it wasn't illegal. The trial court overruled the motion, finding that it had jurisdiction, but it declined to rule on the question of whether the complaint stated a cause of action. This court also found that the circuit court had jurisdiction, but carefully stated that, this meaning the Supreme Court, carefully stated the jurisdiction depends on not whether the relief asked is available, but whether the court has power to hear the kind of action brought. Thus, the circuit court has jurisdiction to determine whether the plaintiffs, in fact, have a cause of action for damages for unlawful discrimination. Meaning, there's really no question that a circuit court has the jurisdiction to hear the motion to dismiss. Concerning this latter determination, the court made no decision, but instead merely found that the trial court's failure to decide was not an abuse of discretion. Thus, the court did not rule on this question, and the decision, therefore, does not support the contentions of either plaintiff or the defendant in the case of Barr. In Ross v. Ebert, the plaintiffs were two Negroes who were refused membership in a labor union. The Industrial Commission found that the refusal solely based on racial grounds recommended that the union admit the plaintiffs as members and publicize its findings. The sole statutory remedies under Chapter 11. At the time, when the union continued to refuse them admission, plaintiffs sought injunctive relief in circuit court. This court upheld the trial court's decision substaining demurs to the complaint, basically motions to dismiss. First, the court said Chapter 111 did not actually declare discrimination unlawful and therefore did not create any new legal rights. Ooh, jeez. This portion of the opinion is no longer viable since the law is now expressly declares discrimination unlawful. Okay, we're going to pause here. There's so many great examples of this, but I know I've mentioned this before. Even as late as the 1920s, England was putting workers into jail for failing to appear on their contract. So you might have a contract for a year at a certain rate. During that year time, wages might go up. You might want to get more wages and try to go work for somebody else. If you went and tried to work for somebody else, you could, or for other reasons, you could be put in jail on contempt. The boss would go into court, get an injunction for specific performance to have you appear for your contract. You wouldn't do that. Then the court, you would be held in prison for your contempt of the court order. And I think that would just be renewed every 30 days. But the point of that is that the law, the Commons kept changing that rule. I think this happened 5-6 times over the course of 40 years. And the courts would simply just change what it meant and interpret it in a way so that you can continue to jail workers. So this right there is, I think, one of an example of that sort of move here where the legislature says it's illegal to discriminate, but they don't use the words it's illegal to discriminate, and therefore the court said it didn't actually declare discrimination unlawful. It just said we don't want riots, so hey, what the heck? So no new rights. All right. Thank you for that. We are at 24. But if such a right was created, we must look to the statute to see if the remedy or a penalty for a violation is provided. If it is, that remedy is exclusive. Oh, I like that one. That is these are important ones. That basically says there may be implied remedies, like you may be able to sue somebody, but if the statute gives you a mechanism to sue somebody or whatever it is, to enforce it or not to sue somebody, then you can only do what the legislature says. Bam. Where the law gives a new remedy to meet a new situation, the remedy provided by the law is exclusive. And I mean, there's good and bad by all that, but I think that by now the legislature is on fair warning that if they want to put a remedy in there, they better be pretty darn explicit about it. Investigation, publicity, and a commission recommendation are what the statute provided. In consequence of discrimination practiced by an employer or a union. We grant it is cold comfort to appellants, but that is all the legislators saw fit to provide. All right, they're quoting themselves, basically. The court also held that Article 1, Section 9 of the state constitution did not require the court to provide a remedy for racial discrimination. Plaintiffs' attempts to distinguish Ross on the theory that the court solely held that discrimination by labor unions was not covered by the applicable discrimination statutes, this interpretation is wrong. The statute did cover such discrimination. Moreover, the Industrial Commission has already determined, as in the instant case, that the plaintiff had been discriminated against. Thus, the issue presented to the court in Ross was precisely the same issue presented here, whether the plaintiff could receive relief through a civil action unavailable from the administrative agency. And that's what it's all about here, is why are we sort of stuck with the DWD? I think that's the big question here. Why is the Wisconsin scheme so, why is it not working for Wisconsin workers? Tony Evers. All right. It must be noted, however, that the decision in Ross was substantially based on legislative history, indicating the legislator intentionally failed to put teeth in the employment discrimination statute. I wonder why. It was clear in Ross that the judicial creation of a private cause of action for injunctive relief would be contrary to the legislative intent. That means make this union stop, use your power as a court to make this union stop doing this, and then put them in jail if they don't do it. It's recently created by Chapter 268, yada yada, now permits the department to award back pay. The new subsection represents legislative determination that the statutory rights of those discriminated against were not adequately protected by the availability of prospective relief only. All right. So we're going to pause here for right now. We're going to get into some more, I'm sure. This, I think, is fascinating. I don't know about you, but I find this to be this history of employment law here and the lack of remedies and how preposterous everything was to be fascinating. But let's also remember that this is a big fight here. And they're fighting one of the biggest. Montgomery Ward is one of the largest department stores at the time. It got killed by Amazon and Target and things like that, Walmart. But this is big powers here. This is the big power employer. They're going to have the best attorneys around. So this, I think, is fascinating. All right, stick with us for part 2.